We now intend to look at these four, where they apply, in which cases where you may have sought these remedies, but you may not be granted, so the limitations as well to these remedies. We start with certiorari. So which are the grounds for award of this contract? For the award of this, we talked about ultra vires, where a body has acted beyond the powers which they possess. And in that one, we looked at the case of the chief and the assistant commissioner, the district commissioner, purporting to retire him on those grounds of public interest. So his award was granted. We also see where there is an error of law on the face of the record. We must also remember that this remedy is discretionary. And therefore, where there is an alternative remedy, the court will not be fast in granting this award of certiorari. And where that is also not applicable, it will readily issue. Where the applicant is somehow to blame, the court may not be very fast in issuing this award. And also, where the applicant has no locus standi, where you have no legal authority to stand before a court of law and ask for a remedy, you are not recognized maybe in that matter, you are not recognized, you have no legal basis to ask for something. Therefore, it cannot be granted unto you. And where you seek to protect a privilege, you see the Constitution provides for rights. It does not provide for privileges. And rights are across the board. They are for everyone. Privileges occur due to certain circumstances, maybe birth. We can talk about diplomatic immunity. These are privileges. They are not rights. So these orders cannot be granted because of privileges. They can only be granted where a right has been infringed upon. So for this, we can look at this case of the Kenya National Examination Council versus the Republic, ex parte Geoffrey Gadenji Njoroge. It was a civil appeal, number 266 of 1996. It talks about the functions of the Kenya National Examinations Council, and Section 10 of the Act of the National Examinations Council Act is that they conduct academic, technical, and other examinations within Kenya as they may consider desirable in the public interest. So that the Section 10 is what was in contention. That by Section 14 of that Act, the Council had power to make regulations for the conduct of its business. So the issues were, the Council conducted KCPE. Geoffrey Gadenji was the first respondent, who is a proprietor of a primary school, manned by a teacher. Probably other teachers were there. In 1994, the pupils therefore offered themselves to be examined, and the examination was to be KCPE. A total of 7 subjects were taken. So after taking the examination, the council released to all the 9 of them the results of the 5 papers. And according to them, it constituted a fair assessment of the candidates' respective performance. But the council did not release the results in respect of two papers, Science and Agriculture and Art and Craft and Music. And the council informed the head teacher through the District Education Officer, Kiambu, that their results had been cancelled because they have been involved in examination irregularities. And they were to bring that to the attention of the candidates affected. So the first respondent, Mr. Njoroge, was not amused by the council's letter. So he wrote back to the council, giving it an ultimatum of 24 hours to either do two things: release officially the results or disclose to the school in writing the examination irregularities the candidates were alleged to have committed. So, of course, the 24 hours was not complied with. 17th January, Mr. Njoroge writes another letter asking to be given a reply. And the council secretary instead wrote to the headmistress, and they said that the council treated all similar cases in the same way and would not change its policies and subsequent decisions on the matter, quoting the section 10, that if the council is satisfied and it had no other further obligation to give detailed accounts of the irregularities committed as requested. Therefore, the educator was supposed to communicate to the affected candidates and a plan to avoid cheating taking place in your school in future examinations. That is read verbatim. So what did Mr. Njoroge do? He went to court and they sought for orders of prohibition, prohibiting the council, as well as seeking them to release the KCP examination results. So the court held that the council is under legal duty to act fairly. Fairness must be self-evident. It cannot be evident unless any adverse acts leading to the conclusion and final decision and action are disclosed, stated, and communicated. And the relevant particular circumstances leading to the decision must be shown. It means that the examination body must have stated why, its reasons for doing what it did. And it cannot be shrouded in secrecy. The course of events leading to the withholding must be sufficiently set out so that from looking at them, the court is clear that the council did not take anything which it not ought to have considered, and it confined itself to relevant matters and acted with what the mandates of the Kenya National Examinations Council was supposed to act. So the court held it shall not permit any public official, including Kenya National Examinations Council, to hide under secretiveness and that element of not wanting to say what were these irregularities. The acts must have been stated and proved. So in doing so, it's a long case, but eventually what the court held was that they recognized that cancelling the results is not the same thing as failing or passing. A candidate may have passed in the council results. It's obvious that in cancelling a result, considerations other than the merit of the performance must inevitably come in. So, had the respondents sought an order of certiorari to quash the cancellation, have been required to justify to the court the reason why it thought the respondents had cheated. So in this case, Mr. Njoroge never sought the correct orders. He sought a prohibition and a mandamus, but he never sought for the cancellation to be quashed. If he had done that, it remains that it would have been enough for the court to ask why. For the court to ask for evidence that the students had cheated, while maintaining the fact that the marking of examinations must retain confidentiality, but not secretive. So in this case, the order was not granted to quash the council's decision in cancelling the results, and it was futile for the respondents to insist that they must get cancelled results, because in the court's opinion, the cancelled results would be of no use to them. So the orders that they were given was that all orders dismissing this, the council be prohibited from withholding, or it could be compelled to release. So the appeal succeeded, and Njoroge he sought the court to give them their results. And his action went through and it was upheld. So what do we mean by certiorari? It's where you go to a higher court and seek to have that decision that was granted by that lower court to be reviewed, to basically be looked at. Did it follow the law? Did it follow the procedures? And the higher court has that authority to send back that decision and lift what it determines as being unfair, as being against the principles of natural justice. That is what we mean by certiorari. It's a court process. So we go back and this we have dealt with. We now move to, so an order of certiorari quashes a decision already made. So that decision where the Njoroge and his students, it was quashed. Now we look at what prohibition is. It's to forbid an inferior body or tribunal from carrying out a quasi-judicial function in which that body has no jurisdiction to do. We also go back to the same case. For these orders, we go back to our case of Geoffrey Gadenji and the Republic. He had also sought orders of prohibition. And in his orders, the first responded, Mr. Njoroge, wanted that an order of prohibition directed to Kenya National Examinations Council, prohibiting it from withholding the results of his school. He wanted them compelled to release those results because he felt that they were unfair to him in holding them back. It's a prerogative order which prohibits the lower court. You see, all these that we seek, they come from a decision having been made by a lower court, and that lower court, you feel that it either went above what it needed to go, the doctrine of ultra vires. It also went against the principles of natural justice. So when you seek a reward, you seek an order prohibiting what that judgment that was against you. In that case where the NEC appealed against the owner of the school, the owner of the school had been granted those powers. So it appealed against that the lower court had made an error in giving that Mr. Njoroge the chance to get his results. So they were seeking that order, prohibiting, insisting that the lower court went against Section 10 of the Kenya National Examinations Council. And the court held that while confidentiality is maintained, secrecy is not entertained. NEC held that the lower court had no jurisdiction. It acted ultra vires. It acted above and beyond the powers granted in issuing that prohibition, in issuing those orders, forcing them to release the results of those cancelled results. So what they sought was that order of prohibition to stop the lower court from forcing them to release these results. So the High Court orders the lower court from proceeding with that judgment and the ruling that they made that puts NEC at a disadvantageous position. So having covered that, we talk about Mandamus. And it's a command issuing from the High Court directed to any person, corporation, or inferior tribunal, requiring them to do some particular thing which appertains to his or their office as in their nature of public duty. We will still go back to NEC versus Geoffrey Gadenji. Geoffrey Gadenji wanted NEC to release their results because that is the work of NEC, to not only examine, but to release the results. So the order must command no more than the party against whom the application is made is legally bound to perform. But where general duty is imposed, Mandamus cannot require it to be done at once. So in the case of NEC versus Geoffrey Gadenji and 9 others, Halsbury's Law of England is what was referred to. And the law said what they meant that the order of Mandamus compels the performance of a public duty, which is imposed on a person or body of persons. And their failure to announce these results led to the detriment of these candidates. They could not proceed. In that era of KCPE and moving to high school, you could not proceed without your results. You could not be placed in a secondary school to complete your secondary, that was the 844 system, whereby after the 8 years of primary school, you do the KCSE, Kenya Certificate of Secondary Education. You move to the 4 years of secondary school. Without the results of your KCPE, you could not move forward. You could not be placed in any school, or you basically, there's nothing you could do. So the order of Mandamus was to compel NEC, release these results, these ones that you're saying you have cancelled. And the court, if you can remember what we read, the court said, we have no way of knowing whether these cancelled results, whether they had passed or failed. You see, that's the issue. When they cancel because of irregularities, had they failed or had they passed? NEC covered itself in secrecy, not in confidentiality. And Prohibition looks to the future. In that ruling, it says Prohibition looks to the future, so that if a tribunal were to announce in advance, it could consider itself not bound by the rules of natural justice. And the High Court would be obliged to prohibit it from acting contrary to the rules of natural justice. But where a decision has been made, and we're talking about jurisdiction, whether the lower court had the jurisdiction or did not have the jurisdiction to order that, and while Prohibition cannot quash a decision that has already been made, it can only prevent it looks into the future. You cannot prohibit something which has already been done. That has already been done. So, how do we correct what has been done? We issue an order of Mandamus. You are told to remedy the defects of justice so that justice may be done. This same case gives us the difference between Prohibition and Mandamus. You cannot be prohibited. You see, the results were already cancelled. The NEC had already communicated that it was not going to release the results of the candidates. That one was done for them. So which order did the court seek? Did the gentleman seek? He sought Mandamus, forcing them to release these results. And the order must command no more than the party against whom the application is legally bound to perform. Its next duties according to the act that forms them, that forms it, that it must not only conduct these examinations, it not only sets the exams, it marks the exams, it releases the results. It's their mandate, it's their coexistence. We will go back again to our assistant chief. And for him, the only order that could be used was to quash that decision that led to him, because the court had acted, not the court kindly, the DC had acted beyond the powers granted to him by the public service. He could not be prohibited from acting. The decision, he had already done the decision by writing a letter. So what is needed is for him to restore this assistant chief, Geoffrey Kirago Njogu, to the position he was in after the criminal case acquitted him of all wrongdoing. We must remember that these remedies are discretionary. And as we had discussed, where the court feels there's another way of doing things, it will not order them. The court has a very wide discretion what relief to grant, and it takes into account the conduct of the party applying, and takes into consideration undue delay, the conduct of the parties, the irregularities complained of, and whether this grant is unnecessary or futile. And if this grant is issued, will it cause chaos? And will it cause public inconvenience? And what about third parties who deal with the body in question? If this order is granted whereby everyone is allowed to now access, even those who had no issues prior to their results being cancelled, will it bring chaos into the marking world of NEC? Will it also bring chaos into how results are announced? So the court will use its discretionary powers to grant these remedies. And they may decline to issue if these remedies go against the public interest. Even if it holds and declares that the decision was made unlawfully. At any given time, the public interest will supersede your individual right, where it seems that individual right that you want to seek and to uphold will cause more harm than good in the future. You know, we talk about ambulances and giving them right of way. So what happens when an ambulance causes another accident while rushing to take someone to hospital? Ideally, you give way because of that, the greater good. You're in good health. So you allow this sick person to be rushed to hospital. Now, if you block that ambulance and you want to go to court and seek that, you must also have the right of way. You had the right of way. You may not be granted that remedy because it's against public interest. Your rights are not superior to other rights that other individuals have. If we are a group of people and your rights infringe on all of us, yours are not superior to ours. So the orders may not be granted. And in that, we consider the Republic versus Mwangi Kimenyi Institute Kipra, ex parte Kipra. And the court held that judicial review remedies are discretionary. And the court has to consider whether they're the most effectuous in the circumstances of the court. Judicial review is in the purview of public law, not private law. This means, as we have said, the greater good of the public is considered more than your individual good. Where the reviews you seek will harm others more than they'll benefit you, the court may not grant you that review. Habeas corpus is a remedy being sought. So what do we mean by habeas corpus? In not so many words, it means produce the body. This normally happens when you are arrested and come tomorrow morning, you're not produced in court to answer the charges for which you have been arrested. Your people or the people concerned about you or your advocate will ask, where is Ian? He was arrested yesterday at maybe Parklands police station. We expected him to be brought to court today. So where is Ian? And the confusion that will arise, but the court will direct. Before we proceed, you need to produce Ian. So in not so many words, that's what it means. It's in common law, issued by a judge or a court. for one who holds another in custody to produce the person before the court. You see, you cannot answer your charges in absentia. And it cannot be adjourned every other time because you're not in court. So where are you? So the court says you need to be produced. If the police are the last people you were last seen in a police cell, they will be asked, where did you take him? Which is enshrined under Article 25D and 51D of the Constitution as a fundamental right. And Section 389(1) of the Criminal Procedure Codes, they provide the orders that the High Court could issue.